Accused murderer Bryan Kohberger is headed back to court, but first, his defense team is demanding the prosecution turn over new evidence they say is vital to the case. Plus, Kohberger's defense team adds a new face with experience in capital cases. But does that mean he will face the death penalty? We take a deeper look at the latest developments in the University of Idaho quadruple murder case.
It alleges that the defendant, Bryan C. Kohberger, on or about November 13th of 2022 in Latah County, Idaho, did willfully, unlawfully, deliberately, with premeditation, and with malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing Xana Kernodle, from which she died.
In November of last year, 4 University of Idaho students, Kaylee Gonzalez, Madison Mogan, Xana Kernodle, and Ethan Chapin, were found stabbed to death in their off-campus home. Weeks later, investigators arrested Washington State University PhD student Bryan Kohberger. At the time, he was at his parents' home in the Pocono Mountains of Pennsylvania. After the start of the year, Kohberger was extradited from Monroe County, Pennsylvania to Latah County, Idaho. Since then, he's been held at the Latah County Jail, only about 1 mile from the grisly crime scene. Ahead of next month's preliminary hearing, Kohberger's defense team is demanding new evidence from his arrest be shared.
Anytime you have a homicide investigation, law enforcement is going to want to attempt to look for any type of evidence, whether it be forensic or otherwise. And that would include any place that the defendant lives or lived. And in this case, they had gotten into his home in Pennsylvania. It appears that there is evidence that they recovered. Some of it may even be blood evidence, and the defense has every right to review that evidence to see how significant it is to their defense and their strategy.
Law&Crime legal analyst Julie Rendelman says it makes sense that Kohberger's defense team wants information from his arrest in Pennsylvania, even though it was thousands of miles from the crime scene in Idaho.
Certainly when you're a defense attorney going into any type of hearing, you're going to want to have all the evidence in front of you because you're going to want to be able to potentially cross-examine witnesses that testify. And that would certainly include any actions taken by law enforcement to create potential probable cause for his arrest, and to be able to establish or argue that some of the evidence they recovered is either not reliable or witnesses are not credible.
This comes as investigators publicly reveal items that were recovered at Kohberger's Pullman, Washington apartment and storage unit, including hair strands, an Amazon Fire Stick, and a computer tower. But it's additional evidence that Kohberger's team is now seeking. According to a motion filed on May 4th, Kohberger's defense wants 6 key pieces of information turned over to them. That includes all body and dash camera recordings from Kohberger's arrest, all lab testing from any items collected at his parents' home, in their trash cans, or in his Hyundai Elantra, additional lab testing from FBI forensic reports, all recordings and notes from the Moscow Police Department, and any audio or video recordings from Kohberger's arrest and jail time back in Pennsylvania. Kohberger's attorneys had previously filed 2 motions in February and March for the evidence to be handed over. But according to Rendelman, there could be a good explanation why it hasn't yet been provided to the defense.
It's certainly possible that the prosecution has some or all of the evidence and they haven't provided it. There can be many reasons why they haven't. One is because the evidence is voluminous and they're really just putting it together in an organized fashion. Another reason can be sometimes that there is a potential protective order, meaning there's something in the evidence that they think that certain parties shouldn't see yet because of some potential danger to a witness. And the third reason, which is possibly one of the most likely ones, is that some of the evidence they may just not have yet. Lab reports take a very long time. DNA takes quite a while. And so it might just be that they don't have it in their possession to provide it to the defense at this point.
We are going to ask the court to set preliminary hearing out into June. We would request the 3rd or 4th week of June and probably 4 or 5 days for preliminary hearing. Mr. Kohberger understands his right to a timely preliminary hearing, and he's willing to waive the timeliness to allow us time to obtain discovery in this case and be prepared.
With a June 26 preliminary hearing date, Rendelman says Kohberger's defense could request it be pushed back if they don't receive the information in time.
Look, a preliminary hearing is kind of a determination as to whether or not there's enough evidence to go to trial. So if I'm the defense attorney, I'm going to want every single piece of evidence that is relevant to the case. And by the way, I'm going to want a piece of evidence that the prosecution doesn't necessarily think is relevant, but I may think it's relevant. And I'm also going to want any type of evidence that might be exculpatory, something that might lean away from my client being the person responsible for this case, for this crime.
The June preliminary hearing is slated to last multiple days, and while that's not a common occurrence, Rendelman says it makes sense in Kohberger's case.
Anytime you have a case of this nature that's dealing not just with direct evidence, but actually circumstantial evidence, you're going to really want to connect the dots for the judge. You're going to want the judge to understand why each piece of evidence relates and is relevant to proving that this individual committed a crime. And that takes time. It's very different than a witness getting up there and saying, I saw this individual commit a murder. When you're connecting the dots, when you're taking cell site information, forensic information, possibly downloads from a computer, it takes time to put that case together. And that's why it may take several days before the judge.
As Kohberger's defense prepares for the lengthy prelim, a new capital qualified attorney is added to the team, in addition to Kohberger's court-appointed defense attorney, Ann Taylor.
And Mr. Kohberger, would you like to represent yourself, hire a lawyer, or see if you qualify for court-appointed counsel?
I have court-appointed counsel.
Court has reviewed your application for attorney at public expense. I do find that you are indigent and do qualify for court-appointed counsel. I will appoint Ms. Taylor to represent you in this case.
As of Monday, Eliza Masseth is now listed as co-counsel for Kohberger. A graduate from the University of Idaho, Masseth rose to fame when representing John Werdeman, a one-time America's Most Wanted criminal who was sentenced with 4 life terms for attempted murder and kidnapping. Masseth helped to have his conviction overturned. She's also qualified to defend people charged with the death penalty, something Bryan Kohberger could face.
And the maximum penalty for this offense, if you plead guilty or are found guilty, is up to death and imprisonment for life. Do you understand?
Yes.
But according to Rendelman, Masseth's addition to Kohberger's team doesn't necessarily mean he will face the death penalty.
We've learned recently that there is a new attorney that's on the case that has handled capital cases in the past. There can be several reasons. One is because there's an expectation that they may be heading in that direction. Also, keep in mind someone that has that experience is going to be experienced in any way in murder one cases and investigations. And so getting them involved early on can be incredibly helpful to the defense team.
So far, the prosecution hasn't announced whether it will seek the death penalty in the case. Experts say that's a difficult decision to make.
There's so much that comes in to that decision making. And one of the big issues is about the families. Very often the prosecution's office will talk to the family to see what they want. Not that they're a deciding factor, but there's certainly a factor. You want to know what the family wants. And it also depends on the strength of the case. Is this the type of case that they think they'll be able to get the death penalty if they pursue it? So I think there's a lot of factors that are going to come into play when they're making that determination.
But as of now, family members of the victims are not allowed to speak out about the case. This stems from a strict gag order put forth in January, blocking attorneys representing victims' family members from speaking publicly.
It's very unusual, and I think it's improper. The victims are not parties to the case. And so when you think about a court imposing rules for the trial, and that's essentially what this is, the court imposing rules for the trial, it imposes those rules on the parties. So in a criminal case, it's on the prosecution, it's on the defense. It can be on witnesses once they testify and are subject to the jurisdiction of the court. But it's very odd to have a gag order like that apply to people who aren't part of the court proceedings, directly part of the court proceedings. And I think it's dangerous territory to sort of go in that direction.
As Law&Crime Network reported, victim Kaylee Gonzalez's family is now challenging that order, arguing they have a right to speak. A hearing about that issue is set for May 25th, and so far, there's no word whether Kohberger will attend. Rendelman says even if the gag order is lifted, though, we may not hear from family members about this death penalty option.
The question is if the judge puts that gag order to the side, are we going to be learning additional information or more insight into the case? My guess is that we very well may not. Even if the judge were to say, you can speak publicly or your attorneys can speak publicly, I still don't think that any member of the family is going to be speaking about any of the details regarding the evidence in the case or what they want to happen. And I think the reason is that the prosecution is not going to want them talking about these things. They want to protect their case. They want to make sure their case stays as strong as it can. And they don't want any information getting out there that they're not ready for the world to see.
Rendelman says it's the prosecution's job during the preliminary hearing to prove that there's enough evidence to go to trial. In this case, she says that's a near certainty.
Is it possible that the judge could throw this case out and say there's not enough evidence after a preliminary hearing? Well, certainly anything's possible. Do I expect that? Absolutely not. We certainly have heard, and assuming this is true, that there's one piece of evidence that in and of itself would make it impossible for a judge not to go forward. And that is that the knife or the sheath, found at the scene has his DNA on it. To me, that in and of itself would be enough for a judge to say, we're going forward to trial.
Kohberger's preliminary hearing is now set for June 26th. Law&Crime Network will be there in Latah County, Idaho to bring you the latest developments during the hearing. Reporting for Law&Crime Network, I'm Sierra Gillespie.